May it please the Court, the appellant appears by and through counsel Kate Zygtema. I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you, sir. This is the co-defendant to the case the court just heard, so we have the same factual scenario with the difference that Mr. Stafford was accused of being the male perpetrator of these offenses. I briefed several issues. I only intend to touch on a few and rely on the brief for the remaining issues because there were quite a few I raised. First one I would like to raise is the failure to sever these trials. I think that was an error in part because we have antagonistic defenses. A united front was presented at trial after the motion to sever was denied because, of course, in trial practice you have to present something to the jury they can hold on to. In this case, the issue is ID. The victim clearly could identify her mother, explain her mother, knows her mother. The issue becomes who was the male perpetrator involved. It's our position that because they were able to join the trials, not only did that strengthen the identification, well, she identified the mother, she must identify Mr. Stafford correctly, but also prejudiced the defendant because this girl was clearly traumatized, even by the sexual abuse or even just prior to the sexual abuse. She had horrific living conditions. She'd been removed from the home prior for food, failure to provide food, dirty conditions, etc. So there's such an issue there that...
Could you back up here? What's the antagonistic defense prior to severance? Was that your claim that the mother can be identified?
What it was...
Did the mother say that, was her defense it happened or what? But can be identified? Well, yes, she can identify her mother. How does that create an antagonistic defense?
Well, the issue becomes that instead of being able to say, I don't know what happened to this little girl, maybe she was abused, maybe she wasn't, but I wasn't the one that did it. Now, because they're together, if he starts pointing the finger at Miss Wells, it damages all of the defense, so the only thing left really to proceed from a practical matter at trial was to attack her credibility as a whole. Because they weren't severed, it cut off an avenue of the defense to concur with some of the state's evidence, saying, yes, the mother may have sold her into prostitution, yes, the mother may have done this, yes, the mother may have done that, but it wasn't me. Instead, when you're joined with this woman who sold her child, when you start pointing the finger at her, the guilt comes back on you as well, and that was the error in severance, is that there was an antagonistic defense in that Mr. Stafford could have proceeded against Miss Wells as the defendant and the one who did do these actions, but with a third party. So I think that the court erred in not granting severance, and therefore he couldn't present the antagonistic defense without severely risking or increasing his likelihood of conviction by not presenting a coherent, palpable defense to a jury. It's hard to, in trial practice, once you're stuck with what you're stuck with pre-trial, you've got to come up with the next best theory, and that's what they went with, was the credibility. But it cut him off pre-trial to be able to present that defense.
Was that the argument that was made in support of the motion to sever, that he wanted to make a defense that, yes, Mom was involved, but I wasn't?
There wasn't a whole lot of pretrial time spent on it. I think the state does, and we both point out, they raised the possibility of antagonistic defenses with Mr. Stafford trying to put blame on the mother and defect blame from himself, but they didn't argue it as vehemently as they could have. They merely raised the potential for that, in part because it was pre-trial. I think it happened fairly early on, and so maybe the defense had not been quite formulated yet, that they just admitted to the court, we have a potential here, but we don't quite know where we're going.
So that at least is in the record, the potential for antagonistic defenses?
Right, the potential for antagonistic defenses is in the record. If there's no other...
Why don't you have to present it to the district court first?
Well, I think they tried to present it pre-trial, at least on some avenues.
Why don't you have to present the argument that you're making to us? Why didn't that have to be made to the trial judge so that he or she could make the decision on severance based on defendant's statement of theory of defense?
I can't. The trial court didn't, but they alluded to it, and so all I can do is expound upon it based upon what the facts of the case were. That seems to be what everybody was hinting at on the record, and perhaps there's some off-the-record conversations that were missing, but that's where they were going in what they presented to the district court, even if they didn't spell it out as much as I did. but that from the development of testimony, clearly that's where the defense would have been going. The next issue that I would address is the failure to allow examination of the complaining witness. The issue was not necessarily her age. You can't find her incompetent to testify just based upon her age. But when you look at the factors to determine whether or not a competency for a witness evaluation should be ordered, there are several that apply here. For one, she had this traumatic history in and out of foster care, abuse that was not related to these underlying incidents. There was some mental instability there for the complaining witness. She had a family history of mental health issues.
Mental health history her own or only family member?
Well, at her young age, she didn't have her own mental health history yet, but she had a brother who I believe was paranoid schizophrenic. There were some other family members with mental health issues, and the nature of those diagnoses sometimes don't develop that early on. But one of the things that was important was she had inconsistent statements regarding this abuse. There was a prior SRS investigation regarding her allegations that found them to be unsubstantiated. She changed her story in telling it to different individuals, from the police to the social workers to even some of her testimony. The additional thing is that with the prior inconsistent statements, that also indicates a lack of veracity, which is one of the factors that I think is the court should have considered. This clearly wasn't a fishing expedition on the part of the defense, which is another issue. There were so many overwhelming factors related to the abuse of this little girl that occurred even prior to the sexual abuse that there's a substantial likelihood that she had some psychological trauma that would both affect her ability to testify and recall these events. She wasn't fed. She was living in cockroaches. From what I understand, it was pretty much hell. She was living in hell even before these sexual abuse incidents occurred. So there were substantial grounds to order a competency evaluation on this witness. Because it wasn't, we weren't able to then get to some of these issues or raise some of these defenses to her credibility, which was ultimately the trial defense, was that the credibility of this witness was not to be believed, in part because these allegations didn't arise until it was time for her to be...
Well, wasn't the concern expressed for an evaluation to the district court? The complaint was how the reason for requesting the examination was how the sexual allegations were reported.
Right, and that's what I was getting to.
That's what the focus was. It wasn't all the living conditions and all of that. It had to do with, it was reported through a foster mother, then through the investigation.
It's my position that all those psychological factors are going to come into play when you look at how these things got reported. She didn't make these allegations until it was time to start working on a reintegration plan with SRS. That's when you might go back here that she started making these allegations.
So why would that require a competency or a psychiatric evaluation of the victim? Why should the court order that in that instance?
In part because children are highly susceptible. That was referenced by the trial counsel. Children are highly susceptible to influence. And if she picked up on the fact that if she said something, she might get to stay where she wanted to stay, that goes to her competency as a witness. It also goes to her veracity and all of those things that come into play regarding her credibility. But since we didn't have any basis or expert testimony to present on that, we got cut off at the knees, so we couldn't challenge her credibility through any kind of psychological basis. The next issue, I'm running out of time rapidly. The next issue with regards to, I'll skip ahead to the comment on the defendant's post-Miranda silence. The prosecutor in closing argument, in his first round of closing argument, argued that the defendant did not jump out of his chair and adamantly and immediately and emphatically deny the allegations. In my opinion, that is a comment on his post-Miranda silence. Just because he did make other statements doesn't prevent him from being able to invoke the protections that they can't comment on post-Miranda silence. Since he didn't testify and he never changed his story, the prosecutor can't use the why did you wait, why did you do this, you testified differently. It's the same thing. You don't have to reveal your trial strategy. You don't have to answer the charges after Miranda.
Was it really a comment on post-Miranda silence or a comment on his conduct when being accused of sexual abuse?
I think what it said was he just sits there, which He just sits there silently. He didn't say anything. And that's the issue. Is you
And then the
can't
suggestion is, well, I would have come across the table or something. There's some sort of protocol for if you're accused
Exactly.
of sexual abuse.
Exactly.
If you're innocent.
Yes, what the prosecutor tried to say is that any normal person who wasn't guilty would be appalled and shocked and come unglued at the mere mention that you could have committed these acts.
He didn't really invoke his Miranda rights. It's really not a comment on post-Miranda silence. It's more of a comment on the conduct that you're supposed to engage in if you're falsely accused.
Well, I think it is a period of silence before he gave his thing. It might be splitting hairs, but I think that to say that you sat there and didn't say what I wanted you to say, instead you sat there silent until you later denied, I think that's a comment on post-Miranda silence, even if he didn't invoke. Particularly because the court noted in some of its opinions, I noted in the 609 letter, there's a whole host of reasons for why people react the way they react in an interrogation, whether they're dumbfounded and shocked or don't know what to say or guilty or innocent. I don't think that you can make those kinds of comments and allege that the defendant sat there and tried to think of an excuse before he denied it just because he didn't react the way that you wanted him to. And I think that that's a Doyle violation that shows ill will on the part of the prosecutor.
You didn't complain about the prosecutor arguing facts not in evidence. You just mentioned that, that's not necessarily the reaction that all innocent defendants would have, but that wasn't in the evidence. Neither was it in evidence that the normal reaction is to angrily and immediately accost the law enforcement officer.
It wasn't facts on evidence. I assume it's hard getting a cold read from the record, but that was the prosecutor's argument. That was his tone, that common sense would be that you would jump out of your chair and do that, which is not correct. There's a whole host of reasons, and I think that making that comment is prosecutorial misconduct, and especially when there's no injuries in this case, there's no overwhelming evidence. Everything has to do with just this little girl's statement. So when you start attacking the credibility of the defendant's denial, that's a problem, and it's not going to be harmless, or it shows ill will, and it's going to be prosecutorial misconduct. I'm out of time. I will rest on my brief for the remaining issues. I don't know if there's any other questions the court wanted to ask about something I didn't get to.
Well, Chief, if you don't mind, I would like to inquire. You made a late request for admission of the drawings.
Yes.
From the victim, and your complaint is that they were improperly admitted into evidence.
Yes.
And you want to explain your position on that?
My position on that is that it's basically hearsay. It was a late request. There was a clerical error that I meant to add them to the record. I noted it in my brief. I was filing a motion to add to the record. I have no idea what happened, that I didn't catch it until now. But those pictures are essentially a pretrial statement. With dealing with this age, there's no reading skills, there's no writing skills, so her expressions are through pictures. So by admitting those through Joyce White and then not cross-examining them, those are hearsay, and it was admitted in violation of the statute.
Didn't the victim testify?
The victim testified, but primarily she said she couldn't really remember.
I don't care what she said, but 6460A says that a fundamental exception to hearsay is if the declarant, who here is the victim, you say she made declarations through her pictures, is available for cross-examination at trial. And she not only was available, she testified and was open to cross-examination.
The problem was that it wasn't effective cross-examination because when she testified, she couldn't really remember a lot about those drawings. So it wasn't effective cross-examination, which is basically the same as no cross-examination, and leaves you back to the hearsay problems.
Do you have some authority for the fact that 6460A does not apply if defense counsel doesn't get answers that defense counsel wants?
Well, I think that there's case law that says that in order to conduct cross-examination has to be effective for confrontation. This isn't a confrontation right, but I don't think it's much of a step to say if we're going to admit hearsay and they have to be available for cross-examination, if they're not able to answer questions, they're not really available for cross-examination.
So as I understand your answer to Justice Johnson's question, you are not able to point us to any published authority to support your position. This is all by reason of your authority.
Correct.
Okay. Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. I also will be submitting a portion of our issues on the brief. If I may, I would like to start with issue 5, which is the issue counsel just left off with pertaining to the drawings. In this court's order, it had requested that the parties be prepared to discuss the effect of the addition of these pictures to the record on appeal. And it is the state's position that essentially those pictures have no effect to the record on appeal because it does not outfit this court with the complete set of tools required to review this issue because we are still without the transcript that sets forth the substance and the basis for the court's ruling in admitting these pictures. Even if the transcript was available, it doesn't support the entire argument that's been advanced here on appeal, which is twofold, that they're self-serving and that they involve an unavailable child witness, which require the district court to comply with the strictures of 6460D. The argument by counsel at the motion in limine hearing was that the drawings were made at the behest of another, that they were overly prejudicial, self-serving, emotional pictures. Notably, counsel referred to SW as the best child witness he'd ever seen in 21 years of practice, that she was not a hesitant young lady who doesn't remember things well. Thus, 6460D was not even a consideration at the time this motion in limine was filed. There is no basis for exclusion of these pictures. SW was available for cross-examination with respect to the foundation for when these pictures were prepared. She was available for cross-examination with the substance of what those pictures depicted. The record reflects that the defense counsel did not even attempt to cross-examine her with respect to those pictures. Now, as far as the time that SW testified on direct with respect to those pictures does not reflect that she was incapable of discussing those pictures. The question to her with respect to State's Exhibit 21, she answered, "This is a bed, this is my mom, this is Reggie, and this is me. None of us have any clothes on." With respect to the pink figure is my mom, the center figure is Reggie, and the far left figure is me. In State's Exhibit 23, that's a bed, my mom, and Reggie. The far left figure is my mom, the center figure is Reggie. Yes, I wrote that I was sad and angry on the pictures. In State's Exhibit 22, that's a bed, that's Reggie, and that's mom. I'm not in that picture. Now, I don't understand, the state doesn't understand from that description how that depicts a child that is unavailable to discuss the contents of those pictures. It's the state's position, first of all, that these don't add anything to the record on appeal in the absence of the transcript, and that nevertheless, if we are going to look at these pictures, there was no basis for an exclusion. At this point, I will visit issue 1, which is challenges the denial of the request for severance. That issue is controlled by 223202, which sets forth 5 factors to be considered when severance is appropriate. Defendant starts his argument that he is requesting relief under the first of these, which is the antagonistic defenses. That is not supported by the motion filed before the district court, nor is it supported by the arguments that were presented to the district court. The motion for severance simply stated that the interests of the defendant in this matter are adverse to the interests of the other defendant. He would be unfairly prejudiced. His theory of defense is most certainly different than the co-defendant's and quite likely adversarial. At the time of the hearing, counsel specifically said, "I don't think we have the strongest arguments regarding severance, but at this point, that's what we're left with is simply potential." Now, the factors that are set forth under 223202 contemplate specific evidence. They don't contemplate potential evidence. In fact, in State v. Pham, this court specifically told us that the apprehension of an adversarial defense is not sufficient to secure severance. For the first time on appeal, defendant argues that had he been severed, he could have presented a defense that the co-defendant or a different individual was the actual perpetrator. That is a factually driven inquiry that is not properly before this court for review. The foundation is not before the court. The specifics are not before the court. That is an argument that should have been made to the district court for an appropriate ruling at that time for this court to then review. Finally, the defendant argues that the failure to sever impermissibly bolstered the weak identification of the defendant by SW. That contention is simply not supported in this record. This child consistently identified Reginald Stafford 6 different times, unequivocally identified Reginald Stafford as the perpetrator in this case. There is not any bolstering that's going to be done for that identification. The second issue challenges the court's ruling that with respect to the evaluation. Now, the evaluation that was filed before the district court indicated that they believed an evaluation was necessary because there was little to no corroborative evidence and because of the child's tender years. There was nothing regarding family history or inconsistent statements. In fact, the family history of mental illness are half-siblings and a stepfather. That is not blood relation to Susie Wells and would not be an appropriate consideration, specifically since it wasn't presented to the district court. As far as inconsistent statements, that was also not one of the factors provided to the district court under the evaluation, and we must keep in mind that this is a 5 to 6-year-old child discussing horrific acts that were perpetrated upon her for approximately a year. This is not a scripted event. I think one would expect that the statements might be inconsistent. But make no mistake that where she was consistent was that Reginald Stafford was the perpetrator of the crimes. The court conducted an extensive hearing on this motion in an effort to discern her ability to tell the truth and her understanding of a truth versus a falsehood. The evidence presented showed that she had an understanding of the importance of the truth, and she understood that there were consequences for dishonesty. The court properly determined that an additional evaluation in an effort to ascertain those factors was not necessary. The next issue, we'll move on to the prosecutorial misconduct claim. Defendant asserts that there was instance of prosecutorial misconduct that occurred during closing argument, complaining that that constituted a Doyle violation. Justice Rosen, I think you hit the nail on the head when you say this is not a matter of commenting on post-arrest silence. This is a matter of commenting on conduct, not silence. The defendant
Is there any basis for making that statement, though? I mean, is there some sort of propriety or some sort of manner in which someone behaves when they're accused of something in an interrogation that they maybe or proclaim their innocence? I mean, you're supposed to come across the table. I don't even understand what the basis of the comment was or what the argument is.
I believe he's just commenting that common sense would dictate that when an individual is accused of a crime of this nature, that they are going to respond adversarially in some way, that they are not going to just merely continue their discussions with the detective as the interview moves forward. Is there a case book or is there a textbook manner in which they would respond? No, and I don't think that's what he's attempting.
What he's suggesting, though, that there's some prescribed manner in which someone normally responds.
I don't necessarily know that it's a prescribed manner, but there would be a response. And his point is that there was no response. But this certainly does not...
Oh, isn't no response silence?
Not when one is accused of the sex crimes of this nature. I think he's saying if you've been accused of...
If you are said you have the right to remain silent, and by the way, I have a little girl that says you sexually abused her. At that point, the Miranda warnings don't apply?
He's invoked. He's already spoken. At this point, what he's saying is I should have selective invocation.
Once you speak, you can't invoke your right to remain silent?
Well,
you can
certainly
invoke
you
it
can.
any time.
But he didn't. He continued to speak. What he's arguing now is I should be able to look back and with hindsight have a selective invocation. He didn't invoke at that time. He continued to speak with the
We're not
detective.
talking about him. We're talking about a prosecutor that said that he should have reacted immediately and affirmatively and angrily. And the fact that he didn't, and he sat there and didn't say anything, indicates he's guilty. And what does Doyle tell us? Once you give Miranda, you can't use silence as indicia of guilt.
Okay, we can't talk about what the prosecutor did without talking about what the defendant did. And what the defendant did was he agreed to speak with the detective and was in the course of speaking with the detective when the detective said, hey, the reason I'm talking to you is because SW has made allegations regarding sexual abuse. And at that point, the defendant didn't respond in any sort of surprised fashion, but he did in fact continue with the interview. At this point, he wants to look back with hindsight and say, well, that was an invocation. He didn't invoke his rights. He continued to speak with the detective. This is not the classic example of a Doyle violation where the defendant sits and remains silent and the state capitalizes upon that and makes issue of that at trial. That's not what happened here. The defendant continued with the interview. This is a comment on his conduct or his lack thereof.
Isn't it really a comment, and an appropriate comment, on credibility? He's really saying you should absolutely not, this defendant is not credible because he didn't react in the way we should expect him to react.
That is the foundation for his
It's a credibility.
statement.
It's a comment on credibility. Is that an appropriate comment on credibility?
Absolutely. Well, absolutely, because that outfits the jury with the tools. They are the ones that assess credibility. That outfits the jury with the tools to assess his credibility. The foundation for the statement was appropriate.
The actual statement was, does Mr. Stafford come across the table? Does he say, what the hell are you talking about? No, he sits there. It's pages later in the interview. Now that intimates that it's silence, that he's talking about it, which defense counsel objected and the court overruled the objection.
The interview has started and he has spoken with the detective. The statements are made and he doesn't respond in any sort of physical fashion to the allegations, and then the interview continues. He cannot look back now and say, oh, I was invoking there. He waived his rights and agreed to speak.
Doyle doesn't require that you affirmatively invoke Miranda. It only requires that Miranda warnings be given. And at that point, the state cannot rely on silence as indicia of guilt. That's all that's required for Miranda.
And I agree with that 100%. I don't agree that a Doyle violation is what occurred here. The defendant agreed to speak with the detective. He continued to speak with the detective. And at this point, he's wanting to look back with hindsight and say, that right there was an invocation. And from the state's perspective, that he cannot do. He has not invoked his rights under Doyle. And for that reason, the state would argue that this prosecutorial misconduct claim cannot stand.
So Doyle requires an affirmative invocation of rights? Is that what you're saying? You just said he didn't invoke his rights under Doyle.
I'm not saying it requires an affirmative invocation, but there has to be some sort of indication that he is invoking his rights, and by speaking and then continuing to speak, that is not invoking his rights. That creates an amorphous line that allows the defendant to weave in and out of that interview to determine I was invoking here, here, and here. He does not get to selectively invoke, and that's what he's attempting to do here.
We have some case law that says that in order to establish a Doyle violation, a defendant has to establish an invocation of Miranda rights and affirmative invocation of Miranda rights. Do we have some case law that says that?
We have case law that says he has to invoke, and under these facts and circumstances, he has not invoked. Even if we agree to disagree, this is not a reversible misconduct claim. We cannot find gross and flagrant conduct. This is not the quintessential Doyle violation where the defendant sits and remains silent and the state then capitalizes upon that at appeal. The innocuous nature of it is evidenced by the fact that when this first came up during the course of the detective's testimony, there was no objection. When they were going through the detective's interview with the defendant and he indicated that the defendant didn't respond in any sort of physical way, there's no objection at that time. They didn't find it so objectionable then. There's no evidence of ill will in this case. As I previously stated, the foundation of the prosecutor's statement was appropriate. He's simply communicating to the jury that when assessing the credibility of the defendant's denial, this is something to look at. This is an isolated statement.
And what he's saying you look at is conduct that didn't occur. He's saying to the jury, this is normal. This would be a normal reaction if you were accused of something that you didn't do.
He's saying,
I know these facts aren't in evidence, but I'm telling you this would be a normal reaction from someone accused of a crime they didn't commit. And he didn't have that reaction, so you shouldn't believe him. Isn't that
he's
what
not
he's saying?
saying that's a normal reaction. He's trying to communicate that one accused would react in some fashion.
Right.
And that he didn't. And that
one
is,
wrongfully accused. Wrongfully accused, right.
Yes. And that is a factor that they can
So
consider.
he's saying he was rightfully accused because he didn't react in a fashion I'm telling you he should have reacted.
He's not saying either one. He's saying, jury, look at this and make your credibility determination. And we also are required to look at the strength of the evidence in this case. The evidence was not physical. The evidence was limited to SW statements. But again, on 6 different occasions, she unequivocally identified the defendant as the perpetrator in this case. The case did not turn on the defendant's delayed denial. The case turned on the compelling evidence presented from the statements from SW. And for that reason, this is not an instance, in the event this court finds it's misconduct, and it remains the state's position it's not, in the event this court finds that it is, this certainly does not warrant reversal of validly obtained convictions. For that reason, the state would respectfully request that these convictions be affirmed.
Do you stand pretty much on Mr. Maloney's position on the alternative means?
Yes, I do, Your Honor.
Anything more to add on that?
I do not. He did an excellent job. I don't know what else I could add to that. Thank you.
Are you his superior?
Maybe not for long after that argument. Thank you.
I just wonder if there was a pay raise in this story. Thank you, counsel. You had reserved 3 minutes for rebuttal.
Thank you, Your Honor. There's really just a couple things to touch on, and I'll start off with, I didn't get to alternative means in my argument. I'll parrot the state's response and say that Mr. Call, I think, did an excellent job arguing it from the same perspective on the defense, and that would basically be my adoption of Brown. I think that there is a difference between the male and the female, parsing it out that way for alternate means of sodomy, as opposed to relegating it to just a definitional capacity. The other issue is I think that the court is correct that not responding is silence. I think that in this case, the Doyle violation is strong because the case law does say if you're going to talk about someone's post-arrest silence, it has to be inconsistent with his trial testimony or inconsistent with their theory of defense. And it's always been a denial. I think when you start trying to attribute how someone should behave when faced with an accusation, you wander back into the territory of, well, if you were innocent, why didn't you tell us you were innocent? Why'd you ask for a lawyer? Why'd you remain silent? It's the same slippery slope if we're going to start commenting on how people behave in their non-response to an accusation.
Assuming it's not a Doyle violation, do you see anything improper about the comment? Do you agree with the prosecutor that there was a foundation for it?
I don't.
As far as credibility?
I don't agree. I think that if it's not a Doyle violation by commenting, it's inappropriate because it assumes facts not evidence. We don't have anyone testifying that all innocent people come across the table and say, oh, I would never have done that. I think it's absolutely inappropriate to off the cuff start attributing emotions to a defendant or someone else that you think they should have. That's just not an appropriate argument, particularly in this case where everything comes down to the credibility of each party. With no physical evidence and no other corroboration, it all comes down to he said, she said, or I guess there's an additional defendant.
People do that all the time in closing argument. I think people argue the inferences that can be drawn from conduct or absence of conduct all the time. because there isn't direct evidence of certain things?
Well,
For example, if somebody claims not to have, well, I just think it happens all the time. If they are present at the scene of an accident, even that you might argue that their reaction was either fit with our kind of common sense or didn't fit with our common sense. Doesn't that happen really all the time? What makes it inappropriate in this setting?
I think it makes it inappropriate because it's not. There is a period of non-response, which is silence. And the court laid out, I noted in my 609 letter the citation, but there's a whole host of reasons. It's not the same as punching someone and saying, oh my God, it's an accident, or continuing to hit them. I think it's a very different set of circumstances because we're dealing with something so out of the ordinary. It's not a car wreck where you get out and say, oh my gosh, I'm sorry, here's my insurance, it's all my fault. This is a child molestation case that is actually probably one of the most horrific I've seen. That to try to say that they have to come unglued, it's inappropriate because it's so outside the realm of normal experience. Some people are shocked, some people just sit there. I think that when you start trying to say that someone wouldn't be shocked into silence, that they should automatically verbalize their denial, that's a post-arrest silence. That's commenting on post-arrest non-response. And the case law says that you can re-invoke and uninvoke and talk and stop talking. It's just that when you start talking about someone has an absence of response that you want them to, I think that's inappropriate.
Counsel, I see you're out of time. Do we have any further questions?
Thank you.
Thank you. Court will take this matter under advisement. We thank both counsel for their arguments and commend you for adopting by reference the arguments on Brown.